Good morning, Mr. Lai. I am Ivy Khan, and I'm going to discuss what the customary international laws are and the importance of the laws. Pursuant to the Article 38, Clause 1b of the Statute of the International Court of Justice (ICJ), the customary international laws shall be applied by the courts as the evidence of a general practice which is accepted by the law. The elements which are required to fulfill in order to prove the existence of the customary international laws include the state practice as well as opinion juries. This was established in the North Sea Continental Shelf case 1969, where state practice was insufficient to prove the existence of the customary international laws. It is because they must be a belief of the states that they have the legal obligation to carry out certain practices, which is known as opinion juries. The importance of the customary international laws is that they are able to fill the void left by the international treaties that is caused by either the absence of authorization of the law or insufficient rules. Another situation where the court will rely on customary international laws is when one of the parties involved is not a member of the treaty. The significance of the customary international laws is equivalent to the international treaty, as the treaty is capable of codifying the custom, but at the same time, a custom can nullify a treaty. They have indeed a high flexibility as compared to the international treaties, as they bind all the states unless there is a persistent objector. Nevertheless, the silence of the states will be deemed as the acquiescence to follow the customary international laws. Although some states would come up with the new practices which might be incompatible or contrary to the treaties, the practices could have been developed into customary international laws, provided that they are accepted more frequently by the other states. As a case in point, the codification of the laws of armed disputes is known as the Geneva Conventions. Nevertheless, they are already considered binding in accordance with the customary international laws earlier before they were listed into Geneva Conventions. In line with the Geneva Conventions, the citizens will be protected where armed conflicts occur. When there is an armed conflict, all the countries are bound by customary international laws. For instance, the evidence can be seen when Taiwan, which was in an uncommon condition at that time, was also bound by the 1949 Geneva Convention's Article 3 during the armed issue. Accordingly, through the codification of these laws has strengthened the shelter provided to the victims. Since the fighting of the terrorism requires the universal cooperation from the countries all over the world, it is obviously shown that conflicts covered by the treaty laws are rather limited and hence the role of the customary international laws very crucial in bridging the gap left by the treaty laws. Despite this, some may argue that the customary international laws will lead to uncertainty which causes them to receive a lot of criticism because they lack clarity. To illustrate, the definition of the customary international laws remain unclear since they are unwritten. The term general practice is not explained in detail. An example would be the customary international laws of the United States might not be the same as in South Africa due to the absence of consent of the other states. In the case of asylum, Colombia and Peru 1950, concerning a local practice, it can be seen that it is impossible to determine the scope of clarity of any custom as the existence of the evidence, which were contrary as well as inconsistent. As demonstrated, the uncertainty of the customary international laws has caused the courts in different nations to struggle when applying the customary international laws in order to make sure the laws are compatible with the domestic laws. In addition, customary international laws are capable of protecting human rights. The court in the U.S. case of Vilatiga and Pena Ayala 1984, which involved death of a family member due to torture, the court affirmed that the human rights are truly protected under the customary international laws and the right to be free from torture is one of them. Another example is the original rights of the native people will be protected. For instance, this can be seen in Australia, where the state struggled to merge the law of custom of the land inheritance regarding the indigenous people. In the Australian case of Marble and Queensland's number 2, 1992 concerning the native title, the doctrine of terra nullius was rejected by the High Court of Australia as it was unfair, and it was stated that the property rights of the indigenous people were not restricted despite the alteration concerning the title of the land was made during the British colonization. Through this, the Native Title Act of 1993 was passed to give acceptance as well as the protection of the native rights. Currently, the property rights of the natives receive absolute recognition in Australia. At the same time, the property rights of indigenous people were also recognized in New Zealand. Meanwhile, under the U.S. position, a case in point will be Johnson and Mintosh, 1823, where the Supreme Court called for the original rights of natives to be upheld. Since the universal attention on the human rights of the Aboriginal people increases, the protection given to these Aboriginal people also increases. This can be seen in the contribution made by the World Bank through the implementation of several policies in order to show respect for the human rights of the indigenous people. One of the policies is the operational policy which was adopted in 1991 to safeguard cultural practice as well as their human rights while carrying out the affairs which were supported by the World Bank after realizing that Aboriginal people had lower confidence in these programs due to the unfavorable outcomes suffered by them. As shown, it is easy to see that human rights are well protected by customary international laws. Despite this, some may argue that the customary international laws lack enforcement. As an example, the enforcement of the domestic laws of each state is conducted by the public service such as the court system, police, military service, and others which are employed by the government. On the contrary, there is no government enforcing the customary international laws. A case in point is Fernandez and Wilkinson, 1980. In this case, the appellant who was detained for 6 months was granted habeas corpus by the judge, providing that the protection of an alien was demonstrated in customary international laws, which is the right to be free from deportation. The decision was yet accepted when the case was appealed, and it was presented that referring to international laws was irrelevant to the current case as the human rights are exactly above everything. Thus, the appellant should be free from the pending imprisonment, but the customary international laws were not taken into account. A similar approach was taken in the case of Florio and Manson 1980. It was seen that international customs seemed to be insignificant to the decisions made by the court. The court did not even express the existence of them. Another example that supports the argument is a South Africa case. Despite it was argued that the arrest of the terrorists in the case of Anuli and Minister of Justice 1978 had violated the customary international laws for arresting, the court which acknowledged that the laws held that abduction of the abductors was an uncertified act which did not restrict the power of the court to exercise its jurisdiction over the abductors. Both cases show that some courts still remain unconfident and doubtful when it comes to the application of customary international laws. Apart from the importance of customary international laws include they create uniformity, which allows the various steps to benefit from the common interest. One of them is the equality between steps. Seeing that social media as an international channel of communication is being used more frequently by the states as a platform to make announcements. As such, both the state practice and the evidence accepted by the states as law can be posted on Twitter. Previously, the ancient methods used to transmit information between the states include verbal communication, where people had to travel from states to states through horses or by sailing, which took a lot of time for the message to be delivered. Besides, the evidence of state practices is more difficult to be traced. In contrast, 98% of the members that belong to the UN Charter have their own Twitter account. The unity between the states is well maintained and apparently conflicts occurs due to the state practice is rarely seen, despite the customary international laws have been long established. To further illustrate, in the North Sea Continental Shelf case, it was stated that the power between the states should be balanced among the states essentially, and also the effect of the customary international laws are valid regarding all the states which are bound by the laws. The practice of one state only will represent the other states. Thus, the uniformity among the states is essential, while they are having such a relationship that relies on each other to achieve equality, which is the common interest of the customary international laws. In conclusion, the customary international laws have been applied universally as well as extensively through the effort of numerous global organizations. Identifying failure of the international customs laws to achieve certain standards does not indicate that the application of the laws is ineffectual or unworkable. Further, lack of clarity should not be said to be a weakness of the customary international laws, because with this, the states are given the opportunities to decide whether the customary international laws fit their own states. Therefore, the customary international laws have not lost their importance yet, and hence they should not be neglected. Thank you.